Today's topic is parenting. What does the court consider when deciding custody? My name is Belinda and I'm joined with my colleague Susan.
We often get inquiries here at Michael Lynch Family Lawyers about custody and what rights do parents have. Of course, parents don't have any rights under the Family Law Act. It is all about the rights of the children. In fact, in Australian domestic law, that is the Family Law Act, the term custody hasn't been used since the early 80s. The terminology now used under the Family Law Act is parental responsibility, live with order, specific issues order, and spend time with. Belinda's going to talk to you a little bit more about Part 7 of the Family Law Act.
The objects of Part 7 of the Family Law Act are to ensure that the best interests of the children are met. This means ensuring that the children have the benefit of both their parents having a meaningful involvement in their lives to the maximum extent possible, protecting the children from physical or psychological harm, from being subjected to or exposed to abuse, neglect or family violence, ensuring that the children receive adequate and proper parenting to help them achieve their full potential, and ensuring that parents fulfil their duties and meet their responsibilities concerning the care, welfare and development of their children. The principles underlying those objectives can be found at Section 60B, subsection 2 of the Family Law Act. Children's best interests are the paramount consideration in making a parenting order.
I'd really encourage you to read through Section 60cc of the Family Law Act. That is what the court must have regard to when determining what is in a child's best interests. Section 60cc2 sets out the primary considerations of the court, and Section 60cc3 sets out the additional considerations. I will read through the primary considerations because they are very important. Section 60cc2a is the benefit to the child of having a meaningful relationship with both of the child's parents, and Section 60cc2b is the need to protect the child from physical or psychological harm, from being subjected to or exposed to abuse, neglect or family violence. There are a number of tools that the judge may use to assist them in determining what is in a child's best interests.
The court may appoint an independent children's lawyer who can also be known as an ICL. That person is charged with the task of gathering evidence about the child's best interests. They may seek evidence from the child's doctor, school, or other people involved in the child's lives. They'll put that evidence before the court and offer a view to the court as that independent children's lawyer. The court may also appoint a family report writer or family consultant through the court system. That family report writer or family consultant usually has a psychology, psychiatrist, sociology background. They will conduct interviews and observations of parents with the child and provide a report to the court setting out recommendations about what's in the child's best interests. When that report is prepared, it will have regard to the Section 60C factors that Susan spoke about, and it will offer a recommendation as to what future parenting arrangements could come about for the child. Whilst that is not binding on the judge, it is the best form of evidence that the court will have, as it's unbiased, and it offers a view for the judge to take on board from a person who has observed the child and parents. Judges can also seek further information and evidence through the use of issuing subpoenas, as well as gathering test results. Subpoenas are issued to other third parties, such as Departments of Child Safety, Queensland Police, doctors' surgeries, Queensland hospitals, and they will produce documents to the court, which will then be used in the court's proceedings to understand what evidence exists about a particular issue. If there's a suggestion that there has been alcohol or drug misuse, there could also be testing undertaken for each party to show whether that has substance.
Just remember that the judge has a very wide discretion when determining parenting matters, and often there is no one right answer. The judge may decide to make the orders that either of the parties seek, or they can make their own orders if they determine that is in the best interests of the child.
I think that's exactly right, Susan. You need to understand that each case is decided on its own merits, and therefore, whilst you've sought the counsel of your friends and family members and understand what occurred in their matter, that may not apply to your matter. So you should get specialised legal advice about your matter, especially if you're participating in court proceedings or looking at starting court proceedings. In that regard, our details will appear below. We offered a fixed fee initial appointment, and we'd welcome you to contact us.